morning to you all. On behalf of Data Security Council of India, I extend a warm welcome to this workshop on cybercrime investigation. I would like to welcome Mr. Nandkumar Saravade, CEO, Data Security Council of India, Mr. Alexander, and Mr. Krishna Sastry Pendyala on stage, please. I request Mr. Nandkumar Saravade to deliver a welcome address and also give a brief introduction to this workshop.
Good morning, ladies and gentlemen. It's my proud pleasure and privilege to welcome you for today's session. I apologize for the late start of the session. Some of you had come with the expectation that the session will start at 10 and actually the program mentions it at 10:30. But here we are, looking forward to some very interesting discussion. The theme of today's workshop is about cybercrime. And as you would have seen from the program agenda, we are trying to cover basically two aspects of the problem. In Data Security Council of India, we are having a safe cyberspace as our theme. And there are multiple stakeholders, as you know, in this field. This is essentially a global commons, as we call it, cyberspace. And the benefits are all there for all of us to see. But some of the risk issues need addressing. And these risk issues will become more and more significant as the penetration of the digital space increases, especially in the Indian context. We are seeing Digital India as the primary program of how governance and government services will be delivered in the country. And all of this is predicated on the feeling of trust and safety in the cyberspace. And there are various aspects to how that can be brought about. But cybercrime is something which affects individuals in a very acute manner. So it is not merely a statistic of 0.0001% or whatever. For that person, it is 100% pain. So that is the perspective we start from, and we look at issues of what is going to affect the cyberspace users, and what are the likely trends in this, what are the countermeasures which are there, and this being essentially an international problem, as all organized cybercrime is essentially transnational. The ecosystem of cybercrime, as you know, is spreading all over the world. There are different elements to it, and it is not a single point problem which can be addressed in any local context. So essentially, when we started thinking about this workshop as a prelude to the annual conference of Data Security Council of India, which begins tomorrow, we thought that we should look at two different aspects of the problem. The first aspect is the domestic aspect, because all of us exist in the local context first, and then we interact with others in another location. So in the domestic context, we have actually a panel which is going to talk about what are the issues in India, how the cybercrime problem is mutating and getting enlarged, what are the steps being taken to improve the capacity and response, what are the difficulties that the local law enforcement sees. And then we have, after the tea break, the second panel, which looks at the existing mechanisms of international cooperation in dealing with the cybercrime problem, and how these elements are going to work together. And obviously, the response time is very low, how that can be improved, and so on. So these are the two main panels of the day. But before that, we have very distinguished speakers on the stage today who will be giving keynote addresses. The first speaker is Mr. Alexander Seger, who is the head of the European Council Cybercrime Program and a distinguished expert in this field. I first met him in 2006 when I was working in NASCOM, and I went to Strasbourg, and where the annual Octopus conference takes place. And I found the whole concept of the Council of Europe Convention very intriguing, and I think this is a great model to look at and examine and then adopt at some point of time. So he will be talking about the convention itself, and then he is also part of the second panel. Thereafter, we have Mr. Krishna Sastry Pendyala, who is one of the foremost cyber forensic experts in the country. He heads this cyber forensic practice in TCS. So we have two eminent speakers. I don't want to stand between you and them, and I look forward to a very vibrant interaction. We will have a few questions after each of the keynotes, and after that we'll go for the first panel. So without further ado, I would now request Alexander to come and make his presentation. Thank you.
Good morning. A great pleasure to be back in India. I think I've been coming here for 8 years now. The first time I was here in December 2008, and which brought the domestic legislation of India broadly in line with the Budapest Convention on cybercrime. The risk with the policy workshop, the good thing about a policy workshop, you can talk in very nebulous terms, and the risk is that one doesn't get to the point and not very practical. So I hope that in my presentation I can combine some policy issues with some very practical issues to help us move forward. I'm from the Council of Europe, an organization which is older than the European Union, is larger than the European Union. We have 47 member states, poorer than the European Union, and which is focused on human rights, democracy, and the rule of law. And we are dealing with cybercrime also against that background in order to pursue these objectives. When you look at the problem of cybercrime, you realize that cybercrime is not just an issue of attacks against machines. It's attacks against the core values of societies. If you look at the theft of private data, that's attacks against the right to private life. If you look at DDoS attacks, denial of service attacks against media, civil society organizations, you realize that it is also an attack against freedom of expression. And if you look at attacks against public infrastructure, against democratic institutions, parliaments, and so forth, you realize it's also attacks against democracy. So we have to look at cybercrime as an attack against core values of societies and against the rights of individuals. And we also have to keep in mind we should not talk only about cybercrime, which means attacks against and by means computer systems, but also about the challenge of electronic evidence in relation to any crime these days. I read the newspapers this morning. There was somebody, a killer was arrested, and the reason he was arrested is because there was location data that proved that he was at a certain point, at a certain spot, at a certain time. That's not cybercrime, but it's electronic evidence on a computer system. So this is what we have to deal with, which means there is the director of the CPI Academy here. Voila. A pleasure to have you here. It means every single police officer in India will sooner or later come across a case of electronic evidence. Every single police officer in India will need to have at least basic knowledge and basic skills to know how to deal with it. And the same would apply with judges and prosecutors and everybody else. Okay? It's a very broad picture. So we're not just talking cybercrime, but cybercrime and electronic evidence. Now, looking at the cybercrime issue, we don't know how much cybercrime there is. Everybody agrees it's completely underreported. But if we set the numbers of cybercrime, the amount of cybercrime reported and recorded by the police at 100, a smaller amount is investigated, an even smaller amount of that is prosecuted, and even a smaller amount of that is adjudicated. I looked at the study that was done by the Organization of American States the other week, and I think the amount of cases reported and then the amount of cases leading to a conviction or to some sort of court proceedings was 0.01%. I looked at some European countries, it was less than 1%. My question is, and this is just against the reported and recorded crime, not even cybercrime in general. If that is the level, can we assume that there is rule of law in cyberspace? Can we assume that there is justice in cyberspace? Can we assume that governments do meet their positive obligation to protect society and individuals against crime? Well, I think the answer is fairly clear. We have a problem there. Now, how do we deal with this from a Council of Europe perspective, you can look at it like as a triangle. We have on the one hand common standard that includes in particular the Budapest Convention on Cybercrime. We have a follow-up committee, that's the committee of the parties, representing the parties to this treaty, that assess also how parties are implementing it, and also that committee can negotiate additional solutions, like protocols to the Budapest Convention. And finally, we have the issue of capacity building to help countries actually all over the world implement the Budapest Convention, but also give follow-up to recommendations coming from the Cybercrime Convention Committee. I'm in charge of this triangle, in a way, at the Council of Europe. So I'm in Strasbourg, in France, for the Cybercrime Convention Committee. I'm the executive secretary of that committee. And I'm in Bucharest, in Romania, where we have a specific office for global capacity building activities. And we do every week training all over the world, in particular those countries that have agreed to join the Budapest Convention or that are parties. So we're doing training in South Africa, Senegal, a lot of training now forthcoming in Sri Lanka, because Sri Lanka recently became a party to the Budapest Convention. The Budapest Convention does three things. It's criminalizing conduct, meaning offenses against and by means of computers, procedural powers to investigate cybercrime, and it provides for international cooperation. This is the three things that this convention does, and we have seen among the parties to this treaty that this is functioning actually quite well. We have 47 parties that have harmonized the legislation, but many others have also made use of the Budapest Convention and are more or less in line. As I mentioned before, India, although India has not requested accession, has not been invited to accede, therefore, to the Budapest Convention, has legislation broadly in line with the Budapest Convention, and the same is true for many other countries. The most recent parties to the convention are Canada and Sri Lanka, which means it's not just the European treaties. And very important, the United States of America is a party since 2006. That's very important because most countries need to cooperate with the US in order to obtain data that is hosted on the IT infrastructure in the United States by US providers. Now there are certain challenges that were not there to the same extent in 2001 when the Budapest Convention was adopted, and that is related also to how to access evidence in a cloud context. Which means when data is somewhere on servers, in foreign or unknown jurisdictions, or in multiple jurisdictions at the same time, or where you have one service provider that is making use of other service providers. You have layers of service providers that have parts of the data, that pull in data from different sources. To whom do you send a mutual legal assistance request? What law applies? With whom do you cooperate? What happens if the data is in transit or stored? Because you have different procedural powers. If you go to a judge and say, I want to seize this data, but then you realize the data is actually in transit, you have to go back to the judge and says, actually, I need an interception power now because I cannot search a computer because it's in transit and so on. This makes it very, very complicated. Apart from the scale and the quantity of cybercrime, the different devices, the increasing number of users and victims, and also technical challenges like virtual private networks, like anonymizers, encryption, and network address translators, and many of these other problems. So how do we deal with this? This is something the Cybercrime Convention Committee, remember, previous slide, parties to the Budapest Convention, are looking into. And the committee, the parties to the convention, are now pursuing several avenues. One is there has been a detailed analysis of the functioning of mutual legal assistance. That analysis, which was done over a 2-year period, was completed in December 2014, so 1 year ago. And we are now following up. There were 24 specific recommendations coming from that. We are now giving follow-up to that. But also, last year, a cloud evidence working group was established to explore additional solutions. And that group, by 2016, in 1 year from now, has to come up with clear proposals. And for example, last week, on the 30th of November, we had a hearing with cloud service providers to discuss with them, and we continue this sort of work over the next year. Now, in the analysis of the mutual legal assistance, and now we have to become practical. You know, where are practical entry points that we can use to devise solutions? When we analyzed the functioning of mutual legal assistance, one thing was quite striking. Actually, most of the requests internationally are for subscriber information. Sort of who established this email account, from which IP address, what are the login data, and so on. This is what you need. As an investigator, you need to know, you need to link the IP address or the attack, which then points you to the IP address, to some subscribers. That's what you need to get started. So if I say 80%, people are unhappy with me because they say it's actually 90% or more of all requests are for subscriber information. Parties to the Budapest Convention every year send more than 100,000 requests directly to US providers to ask for subscriber information. Okay? That's what you need. So that's something to bank on. They also ask for other traffic data, which mean transaction records, metadata. And most of the offenses are not, the underlying offense is actually not cybercrime, it's fraud, financial crimes, followed by violent and serious crimes, and only then offenses against and by means of computers. Okay, subscriber information, keep that in mind. Now the options that we are discussing, or that the Cloud Evidence Group is currently looking into, is, okay, to render mutual legal assistance more efficient, but also to exploit better existing provisions of the Budapest Convention. There are many treasures hidden in that treaty. One treasure is Article 18(1)(b). It says if you're a party to the convention, you should authorize your police to order a service provider offering a service on your territory to produce subscriber information. So what does it mean, a service provider offering a service on my territory? If you can simply access and open a Gmail account, is Google offering a service on your territory? Here in India, if you take that. Really? And does it mean if you were a party, which you're not, but if you were a party to the Budapest Convention, could you then order Google to produce subscriber information? And how do you enforce such an order? If Google says, wait a moment, legally we are in the United States, we are not here, our data is somewhere else, can you coerce? Until 2 weeks ago, everybody said, no, you cannot coerce, because you cannot exercise your enforcement powers on a foreign territory. If you have a communication service provider registered here in India with a license here in India, then you can enforce it. But otherwise it's difficult. 2 weeks ago, after 4 or 5 years of court procedures, the Belgian Supreme Court decided that a request from a Belgian investigative judge to Yahoo, this dates back 5 or 6 years, and then it was contested by Yahoo for subscriber information in relation to, I think, a terrorism case. At that time, Yahoo said, well, if you want this data from us, send an MLA request to the United States. Prosecutor says, but I open my computer, Yahoo is here. If I open the Yahoo page, we have the Belgian weather forecast. We have Belgian seafood restaurants here on the Yahoo website. You're making money here. You're targeting advertisement to Belgium. Yahoo says, no, we are not here. You're somewhere else. Anyway, this went through several instances, and on the 30th of November, the final verdict from Belgian courts was Yahoo has to produce the data. And for every day that Yahoo is not producing data, a certain fine has to be paid. This is the first time that we know of a case where you now have a coercive power. How this will work out in practice, we still don't know. But I mean, this is the sort of thing we have to look into. So Article 18(1)(b), and that's what the Belgians refer to, that what the Belgians have in their domestic law was used for that. Okay, this is one of the things we have to see. How far can we get with domestic production orders under this and how this works? The tendency of providers is, yes, we cooperate, but we cooperate voluntarily. This is the current trend, but we have to probably put a clearer legal framework around it. We're also looking into a protocol to the Budapest Convention as an option to, for example, foresee a light regime for mutual legal assistance requests. Some countries accept a mutual legal assistance request by telephone. Not going through police, going to the prosecutor, go to the judge, go to the Ministry of Justice, goes to the Ministry of Foreign Affairs, and the same on the other side. Some prosecutors in Europe accept a telephone call and they record it as an MLA request and they execute. So, light regime for MLA requests for subscriber information, one option. International production orders. Could a judge in Germany issue a court order which is then directly executed in France? This is the sort of things we're looking into. Emergency procedures. In the case of the Charlie Hebdo attacks in Paris, where French police needed Hotmail accounts, it took 3 hours to obtain the account, not just traffic data subscriber, but the full contents, because as an emergency procedures, because in US legislation there is a possibility for such emergency procedures. Microsoft got the request at 5:30 in the morning in Seattle, 6:15 they handed it over to the FBI and so on. 3 hours door to door, the whole thing, great. Most countries cannot do that because they don't have such procedures. Can we put something in the protocol to the Budapest Convention that all parties can make use of such procedures in emergency cases? This is the sort of thing we need to look into. Anyway, I have to conclude because my friend Nandkumar is getting nervous. I get carried away easily on this. So we have here a situation when we don't have clear international rules yet on how to deal with such situations. We have lots of unilateral approaches by governments. This leads to a jungle of approaches. This creates risks for state-to-state relations. You know, you're wandering about on servers in a foreign territory, you know, national sovereignty and all these things, problem. It also creates problems for the rights of individuals that are normally protected under their domestic criminal law. We need additional international rules. We believe that because we have gone very far already with the Budapest Convention and the parties, that the Budapest Convention is probably the most realistic framework to develop such rules. And seriously, India should be part of this exercise, not only in the future, but as soon as possible, India should become part of these discussions and of these negotiations of international solutions. Thank you.
So thanks, Alexander, for ending on time, firstly, as a moderator. That's my duty. But I think it was a great introduction to the whole framework. And I'm sure there are a few questions. So we'll take just 2 questions before we move on to the next session. So any, can the mic be handed? Then, in the front row. You can take this. Please introduce yourself and just one question, no comments allowed.
Yeah, I'm Dr. Debu Naik. So my question is to Alexander. You told whenever there is something happens, you go and trace the IP address, and then we find out whether there is some evidence or not. So what happens when this IP address has been spoofed from a different place? So is there any mechanism has been placed that to find out the spoofed IP address rather than tracing the IP address which may or may not be correct?
Sure, but at least you know that you don't wait for 6 or 12 months for the information that it's spoofed or that it cannot be traced. You know immediately that you're in a cul-de-sac and you have to pursue another avenue, or you find other ways of investigating it. But if it takes you 6 months or 12 months or longer to get this information, you're just waiting and not able to do anything.
Any other query? Kingshuk?
The biggest problem in this whole thing has been attribution. In cyberspace, attribution, even his question is attribution. Like, let us look at the three biggest events which have taken place in history as a cyber attack. Estonia attacks, the Georgia attacks, or let's say the Stuxnet. So we have actually, attribution has been, we have not been able to attribute. So what are your thoughts to solve this main problem of cyberspace, attribution?
Well, because of the problem of attribution, you need to find out, you need to get subscriber information. And it's not always easy. There's always this whole issue of network address translators, which makes it also complicated. There's the issue of spoofed addresses, there is anonymizers and all sorts of other things. But that's why we have to focus on subscriber information, how to get quick information on that. Also to know whether it's not useful anymore to pursue a certain avenue because the information is not there. That also is important information.
Okay, one last question.
Mr. Alexander, as I saw from your presentation that about 1/3 of the countries are in some way or the other have ratified or accession to the Budapest Convention. Could you please point out 2 or 3 issues which the other countries which have not acceded to the convention have with the convention? And specifically, if it could touch upon India's concerns also.
The countries that have not ratified yet or not acceded yet, there are basically 2.5 reasons. First reason is we want parties to have an effective legal framework in place at the time of accession. So we don't want the country to ratify just to get numbers. Okay, we want to have quality members, so any country that is joining has to have the framework in place. So sometimes we work with the country for years on the capacity building activities to get them to the point before we then ask them, now it's time to join. That's important, otherwise the convention will not function. We don't want just numbers. The second thing is, it takes sometimes a long time, in particular when it comes to procedural powers, to bring them through parliaments. We know that it's complicated. The second thing is the question of politics. I think that may be the main reason why countries that even have the legal framework, that have the capacity, it's a question of making this political move. Some of them saying, we in Asia or we in Africa, we did not participate in the negotiation of the treaty, therefore, and so on. Let's face it, the Council of Europe has one treaty, which has a very boring name. It's a joint treaty with the OECD. It's called Convention on International Administrative Cooperation in Tax Matters. It's so boring that for a long time nobody ratified it until the financial crisis broke out worldwide and governments wanted to have their money back from tax evasion and others. Suddenly, it played no role that the countries did not participate in the negotiation. Everybody joined. I think India also signed up to it. China ratified it. Many countries around the world ratified it because it was more important to get the money back than considerations like not having participated in the negotiation. And the half argument is argument which is only brought forward by one country, namely the Russian Federation. Although they also discuss this with other countries, of course, and it's the issue of transporter access to data, Article 32B, and our Indian counterparts have also at some point raised this. The Cybercrime Convention Committee adopted 1 year ago a guidance note on Article 32B, which also shows the limits of that article. Now many, including some people in India, say, but now it's too limited. Now we don't like it because it's too limited. Anyway, you can never have it right for everybody, but following that guidance note, there should not be no concern anymore. In reality, we probably need more options for transport access, but with the necessary safeguards, this is something we also should look into in connection with the protocol again.
That I thank Alexander for a very wonderful session. Please a round of applause for him.
So we have now next speaker, Mr. Krishna Sastry. He is going to cover the industry perspective. So, what is the interest of industry into this whole framework, the capacity for cybercrime, how does it affect them? And of course, as individuals, we are all interested in it, but also industry has a legitimate perspective on this, and this is what we'll be hearing from him, Mr. Sastry.
So before I go for the industrial perspective exactly, what are the real challenges the industry is really facing today in the investigation of cybercrime? So let me play some statistics, what really the industry's problem is today. I don't know how many of you are aware, if you look at the statistics, the business of cyber security is something approximately $77.2 billion US. That's the industry today, out of which the 70% is something related to the managed services. And if you look at the negative side or the flip side of this one, the global cost of cybercrime is approximately 450 to 500 billion US if you look at the lower end of the spectrum. And companies are losing approximately 6% of their revenue due to cybercrimes, that is as per the latest statistics. And especially the banking and finance industry, if you look at it, they are losing something around 15 to 20 billion US dollars, the revenue what they are getting it. So what are the four major attacks that are really targeting the industry, clearly if you look at it? The first and the foremost is DDoS attacks. Later I will tell you what are the real challenges and why this pathetic scenario is really facing it. The second is the malware attacks, especially the APT attacks that are really causing a lot of worrisome for the various organizations. And what is the outcome of these attacks, what banks are really facing or any industry is really facing is, the first and the foremost is, compared to the 2014, if you look at the 2015, the business downtime has given almost doubled. The second is the cost of investigation, the cost of cleaning their computer systems which are infected with the malwares. Almost it has become 3 times compared to the previous years. And the most worst, if you look at is, the organizations are not in a position to identify that their systems got infected unless a third party says that, boss, your systems got infected with this particular type of malware. Already maybe from the couple of months, some malware is already present in your computer systems. So this is the background in which the industry is really facing it. And let us look at what are the reasons why this is really happening it and what are the solutions especially for this is. The first and the foremost is, if you look at many of the industries, especially I'm talking about the Indian-based industries, the approach towards the cyber security is very, very faulty. So we have an approach something called prevent, detect and react it. If you look at the prevent, the most unfortunate thing is it is mostly vendor driven. And some companies says that you install this firewall and install something, etc. But if I go for investigation, in 90% of the investigations have come across in the last 1 year, as a TCS, if I go for any investigation as a managed services company, I found there is no evidence at all available. The reason for this is, what type of logs they are supposed to store it, how long they are supposed to retain it, how long they should keep it in what format, etc. They don't have a clear-cut strategy. So they are keeping a lot of intrusion detection systems, firewalls, IPS, etc. But the approach is 100% wrong. So they are mostly like prevent, detect and respond. It's a high time they are supposed to move from reactive to proactive to predictive technologies. The second is, in the entire information lifecycle security they are looking at, they are assessing, they are designing and deploying and monitoring and managing it. The neglected portion of the information security lifecycle is something called incident response and digital forensics. So they don't have any incident response plan, even if it is available only on the paper, but really they don't know how to handle it, how to coordinate it, how to mitigate such type of attacks. And third feature I observed in many of the cases is the lack of forensic readiness assessment with them. Where the biggest problem is, they don't have a clear understanding of what type of logs to be collected and how long they are supposed to be retained. So let me cite you a few examples you will understand here. In the last 2 months, I went for investigation of the 3 banks where there is a web server, there is behind it application server, behind that you are having a database server. In between there is a firewalls that are available. We have a clear-cut idea and we are able to identify it and investigate it. The criminal is able to penetrate up to the database server. But what type of data he has carried it is a very big question mark. Because of performance issues, they are not maintaining any log files for the databases. So in such scenarios, it is very difficult to identify what type of data really the suspect has carried out. So the biggest problem we are facing is what type of logs to be collected, what type of logs should be retained, and how long they should be retained, etc. They don't have very clear-cut understanding. There is one of the biggest challenge we are facing in the investigations. And no clear vision or strategy. We have seen they too have incident response policy, whom to coordinate it. We have seen a lot of attacks are happening from the foreign countries or enemy countries, you call it as, because today the industrialization, globalization of hacking has taken place. So whom they are supposed to contact, which government agency they are supposed to contact, etc., they don't have a clear understanding. So what was the need of the hour is the first and foremost is something called the integrated security operations centers. Unless you don't have a clear-cut integrated security operations centers where the security operations center should combine with the incident response and the forensics for the real-time monitoring of the systems, real-time capturing of the data and real-time identification of the various threats, the SOC operations is not going to be fruitful. I've seen several industries where the SOC is given to some company. The incident response is there in the paper. If any cybercrime investigation happens, remember they used to call a third party to identify it. So the need of the hour is combining a superstructured SOC, a combination of security operations center with incident response and forensic capability is the need of the hour. The second point here it is lack of indigenous tools. That is the biggest problem really you are facing it, the challenge. We have a various set of tools commercially available for the host forensics, but really if you look at the network forensics, there is no perfect tool that is as on date. The host forensic tools are going to be solve the problem, especially only for the Windows-based machines, etc. But really, if you come for the Mac and other things, it's very difficult. And every organization has implemented the BOID policies, and the employees are accessing the corporate data by using their mobile devices. And data privacy laws and data regulations have come into picture. If an employee who accesses the corporate information by using his phone or iPad or something, how to differentiate which is the corporate data, which is the personal data, where the data privacy loss is going to strike is another biggest challenge we are facing it. And another point we are facing is something called the capacity building it. The major problem we are facing is, yes, there are some incident responders are available, there are some digital forensic, there is no certification, there is no standardization of tools and techniques which they are supposed to take care. So lack of skill is very, very important. And there are some standards which are readily available which currently the banks and other people are not implementing. For example, if you look at the ISO 27037 standard, which is for the evidential collection, evidential preservation, and identification, collection, preservation of electronic evidence, 27037 standard is the one which everybody is trying to implement it, should implement it. The second is for incident response management also have a set of standards which I never come across anybody has really implemented. Let us take the case of some 27035. A complete document is available how to, organization should have an incident response management team, how to collect the evidences, how to do the investigations. So 27041, 27043, 27035 are the three standards which they are supposed to implement it. And another major problem we are coming across is, if any cyber security incident happens, we identify the IP address from where the attack has come. The next question the banks are asking, whom we are supposed to inform to us. To which police we are supposed to inform, what type of information sharing we should do it with them. There is no clear understanding that is really happening it. And what is the need of the hour is a perfect coordination between the law enforcement and the corporate is the need of the hour. And what the biggest challenge the companies are really facing it. If they inform to the police, it is going to enter into the media. There is a first problem. So there is a lot of reputational damage is happening to the organization. That's why many organizations are reluctant to report the matter. And simply they are identifying where the attack is happening and they are not proceeding further. The second is, if they inform to the law enforcement agencies, the next problem that is coming is the scrutiny by the regulators. So regulators are coming into the picture asking that you have not complied for all these. So that is where the liability issues on the organizations have become very high. That's why no corporate is in a position to inform the matter to any of the law enforcement agencies. And third biggest problem is the law enforcement agencies, the reaction times are very high. Still I can remember a case where one of the nationalized banks in Hyderabad around 4 years back, there is a fraud happened in the bank and approximately 5 crores of rupees has been transferred from one account to another account. We advised the bank to report the matter to the police. The answer we got it is very surprising. If I report to the matter to the police, the loss the bank is going to face is some 500 crores because they will come and seize all the equipment and maybe after 3-4 years they are going to give some report which was of no use. So they are ready to bear that 5 crores and they don't want to lose the 500 crores because the reaction times from the law enforcement is very, very high. And there is no information sharing that is really happening it. On paper only we have seen the information sharing and analysis centers, ISACs. And ISACs has to come into picture especially from each corporate level, banking industry, if you look at any of the power sectors are there. So the need of the hour is the public and private should work together to establish something like information security assurance centers or information sharing and analysis centers. Unless these things are not come into picture, the challenges the corporate is really facing is very high. Their investigations are stopping only at their doorsteps and they are not in a position to go beyond that. So they have to do a proper investigation. They should have a clear-cut mechanism. They should have a clear-cut idea that whom they are supposed to report it. So that that information database should be created and it should be circulated to the other organizations. Then only we can able to do a proper investigations. And data privacy laws and data regulations are varying from one country to another country. So that is another biggest problem we are facing within the organization itself if I try to investigate it. So assume a Rex corporate is having operation in 4 countries. If the fraud happens in any of the countries, the bringing the data from one country to another country is the toughest task. So instead of that, as corporates went into a very good model of forensics, which I feel that we should also implement it, something called the remote forensics. Remotely making the copy of the drives which is present in the different countries and doing the analysis remotely and presenting a solution. That is also one of the solutions that is currently available. So remote forensics is the one approach many corporates should implement it immediately. That is the need of the hour that can solve the problems of data migrations from one country to another country. So these are some of my thought processes, especially what are the real problems the investigating agencies of corporates are facing. Thank you very much.
Thank you for that very comprehensive overview of the gaps on the ecosystem, the preparedness of companies for handling the problem. If you have any questions, we can take a couple of them. Yes, please. Can you give the mic there? Yeah.
Hi, my name is Deepak Mishra and I'm working in EXL service. Leading the information security and digital forensics process. I have got 2 doubts here. Number one, the tools and technologies for forensics that any organization implements. I'll give you an example, the data leakage prevention system and the SIEM system. Now in most of the cases, when the governance team who handle these products, they are centrally based in India or Asia Pac. And then you have got your remote systems in all the geographies. Most of these data for analysis, they travel the countries and they reach up to India. I'll give you just a hypothetical example. Now DLP, which is the most relied upon tool for data prevention. All the artifacts which contains credit card information, health information, they travel to a central place in the security operations center, to one location, and then they get analyzed. Now, in this situation, you are trying to proactively protect the organization, but then the data travels, right, for the analysis. And the same happens in the SIEM world, where the logs travel to the central, because we call it as integrated SOC. Somebody call it as Intelligent Security Operations Center. You can't have, a small organization will not have the locally domiciled SOC. Everything is managed centrally. Now, how will you deal in such situations?
Right. Clearly, if you look at it, even the SOC, the log files, etc., are also part of the data. They are not supposed to move from one country to another country as per the data regulations available in every country, right? So what is the only solution is, you can create a mini SOC, means only a server. Please remember, from the centralized server only the tools are going to operate it. The logs will get located in the different countries, wherever is, because the data need not move from that country to any of the other countries. So remotely we can access that logs and we can make an analysis of the same. So even the log files also need not move from one country to another country. It's only storage servers you are supposed to keep, not more than that.
So imagine the kind of investment any organization
I would
will
suggest you take the question, because I think the query is very deep, so it will require some discussion. So if you can take it offline.
Sure.
Next one, please.
So you touched upon, you touched upon the log retention strategy problem. You touched upon log retention strategy problems and how they are more reactive rather than being proactive. I would like to understand your thought that being a investigator in the field, how we can both utilize full packet capture technologies to be more proactive. And we work with a couple of PSUs in my last couple of years. I see them more relying towards logs and being reactive rather than looking at network forensic side of it. So just want to understand your thoughts on full packet capture.
See, you have to do the deep packet capture analysis completely, and you have to combine that packet analysis with that of the security analytics to identify from where the anomaly detection you are able to find out, so from where the attack is really coming out. There is a set of tools, but the tools are not going to help to a very great extent. So the meaning of here, the proactive and predictiveness is, so based on the log information in a real-time monitor, for example, let me tell you, today most of the viruses are targeting your RAMs, right? So we have established a small demo lab where in a real-time the RAMs can be captured. The data, by using some volatility framework, we can identify, remember, what are the processes that are currently running. And we can create the hash values for the EXEs that are existing in the system. And based on that comparison in real time, we can say what are the new EXEs that are coming and entering the system. So we have to capture the real-time data, and if you apply the anomaly detection and the security analytics, you have a clear-cut understanding that exactly where the pattern of attacks are coming out. So that is the meaning of the proactive and predictive I'm talking about it.
Right. I think many questions. Okay, one last question here, please. Can you give the mic here? Yes, third row.
I'm Director of the Judicial Academy. I have a question for Alexander. In his presentation, he referred to the fact that when it comes to the conviction rates, you find them 1% or 0.01%. Can you elaborate that what could be the reasons for it?
There are many reasons for that. One is the huge number of cases reported, the limited capacity then to follow up through investigations and prosecutions. But even countries that do have lots of investigations, that do have lots of prosecutions, then say they're failing because at the end, in courts, there is no understanding of the cyber issues. There's no understanding of what it means, electronic evidence. There are sometimes unclear procedures regarding to ensure the chain of custody and all these things. And at the end, countries have greatest difficulties to accept electronic evidence and so forth. A lot of it has to do with skills. What we found is that in many countries around the world, law enforcement officers are getting skilled. You know, they're acquiring the skills. There are trainings available. There's standardized training available, and the sort of training you do in India for an investigator, for a computer forensic expert, would be not too different from the training you would give somebody in Sri Lanka or in Canada or in Germany. But for judges, it's very different. You have to design something to be adapted to the specific legislation, to the local context, and so on. That's why we have now been doing this systematically. And as I said, we're now starting it also in Sri Lanka. We're training trainers for judges there. We are adapting training materials to the specific conditions of Sri Lanka. We are supporting the delivery of basic and advanced courses for judges. And all of this should be then integrated into curricula of training academies. So over time, you will get an increasing number of judges that will have the skills. And hopefully, we will then have also a larger number of convictions. But the problems that I mentioned now for Sri Lanka or that you have in India are not too different from many other countries around the world. It's a general problem. The judges have taken their time to catch up.
I'd like to thank both my speakers for a wonderful session, and a great question to be around. To come to the end of this session, I will request executive panelists to please come to speak.
So you do
Thank you very much.